Hello, everyone. Thanks for joining us for the final installment of our 2025 Background Screening 101 series. I'm Alonzo Martinez, Associate General Counsel at HireRight, and I'm joined by Nicole Campion, Associate Counsel on our compliance team. While Nicole and I are both lawyers, today's session should not be considered legal advice. That said, it should give you a strong foundation and talking points to take back to your teams and to your legal counsel. A few quick housekeeping notes. To get HRCI or SHRM credit, you'll need to stay for the full live session. Credit info is going to be mailed next week. You'll see that in your inbox then. We are not sharing today's slides, but we will send you a link to a recording of this webinar. If you have any audio or video issues, hit F5 or use the Q&A icon. Doreen is producing today's webinar and is on standby to help. And we'd love your feedback. Take our short survey at the end of today's presentation. We plan on continuing our compliance education series, so your feedback will help shape the webinars we're planning for 2026. So I'm really excited about today's webinar. Rather than give you a list of abstract topics, we're going to do something a little different today. We're going to follow a single candidate as they apply for a help desk analyst position based in Los Angeles. We're going to walk through the process just like you would in real life, starting with the job posting, continuing through disclosures, background check results, adjudication, adverse action, and more along the way. At each step, we're going to pause through what the law requires, what changes based on jurisdiction, and where employers often get tripped up. And don't worry if you don't hire in LA. We're going to walk through jurisdictional variations so that this stays broadly applicable wherever you hire. Think of this less like a webinar and more like a working session. The goal here is to help you see the entire screening lifecycle in action and give you practical ways to think through your own processes. And remember, use that Q&A button liberally to get your questions in. We love audience engagement. We should have plenty of time to cover those questions at the end of today's session. So with that, let's talk about our job requisition. Let's pretend you've posted a role for a help desk analyst in Los Angeles. You see the details there on the screen. It's a mid-level IT support position, remote hybrid eligible with responsibilities that include troubleshooting access issues, onboarding new employees, and supporting internal systems. It sounds pretty routine, right? But here's what makes this role legally interesting. It's not just technical skills. Let's say this person's going to have access maybe to sensitive data, employee records, system permissions, maybe even payroll systems, depending on how you build your tech stack. So they're not managing money, but they're maybe in the ecosystem that supports it. So what are we thinking? Well, we're already thinking about risk, not just operational risk, but also your compliance risk. What can you ask in the job posting? What checks can you legally run in California? Will local ordinances like LA's Fair Chance Act kick in? And what if this role also supports remote teams across state lines? That is where the screening story begins and where you start making decisions that can either protect your program or expose it. But in California and in many other jurisdictions, it starts well before that. It starts with a job posting. So let's welcome Nicole into the conversation. Nicole, why don't you take us through what's required?
Absolutely. So like Alonzo mentioned, we talk a lot about compliance during the background screening process. We talk a lot about the FCRA. We talk about, fair chance laws and adverse action and all of these things. But it's really important for employers to keep in mind that that's not necessarily where compliance starts. Really, compliance starts right at the beginning of the talent acquisition process. So you've identified that you have a need, you want to hire someone. As soon as you start working on that job posting, that's when you really need to start thinking about your compliance requirements. So for this hypothetical help desk analyst candidate, what are you likely thinking about? Well, as you go through your job posting, again, this is in California, so you're keeping in mind pay transparency and pay equity. So when you go to write the job posting, you want to make sure you're using consistent descriptions and job titles, but consistent with what you've done for other postings. You want to make sure you're including pay scales, clear descriptions of the job, the benefits, things like that. And like Alonzo mentioned, this is California, but there are other states that have these rules too. So don't think this doesn't necessarily apply. If you hire outside of California, just keep that in mind. You want to think about age discrimination measures. So in California, with your job posting, you want to make sure You're not saying anything that would lead someone to believe that you would refuse to hire someone based on their age. And the application is really important here too, right? You want to make sure, first of all, you don't want to include age and date of birth questions. Those are really obvious, explicit indicators of someone's age. But you also want to think about years of graduation. So of course you can ask someone, did you attend college? Did you obtain whatever the degree is that's required for the role? But what you want to avoid is asking what year they graduated from those educational institutions. The theory there being that you could do some rough math and come up with a kind of guesstimate, a range of how old someone may be based on when they graduated. So something to think about. And then, of course, you're going to keep in mind ban the box and fair chance laws. We do talk about these ones a lot, and they do impact adverse action. And we'll talk about that when we get that far. But the impacts of ban the box and fair chance really start right at this early stage. So with your job posting, you're going to want to make sure you don't say things like felons need not apply or no one with criminal history will be considered, right? You don't want to say those types of things. We're hiring in the city of Los Angeles here. So what you would want to say is that you would consider qualified candidates with criminal history in accordance with all the applicable laws. On your job application, when you're putting that together to go behind this job posting, you want to make sure you're not asking questions that are eliciting criminal history information. So of course the box, right? The laws are called ban the box for a reason. You don't want to put that checkbox on the application where you ask someone, have they ever been convicted of a crime? But you want to go a little broader than that and make sure you're not including any questions that would lead someone to believe you are looking for them to give you a description of any criminal history or criminal activity they may have been involved in the past. So with that, we've got our job posting, we've got our application, you started to get candidates, you've gone through all the candidates who applied, and you've picked the one. You have found the candidate who is just the best match for the role that you're hiring. So what's next? Well, likely first you're going to extend them a conditional offer, and then you're going to start your background screening process. So first stage in your background screening process, at this point, let's say you've already got your package designed. So you're not really thinking about what you need to put into the package. You have predefined packages based on the role and the jurisdiction. We'll talk about that in just a couple minutes. So the first thing you really want to think about is disclosure and authorization. So you'll see a few examples on your screen here of different disclosure and authorization requirements in different jurisdictions across the country. This isn't a complete list, so there may be different requirements based on the jurisdiction you're in, the types of screening services you're ordering. For example, if you're ordering an investigative consumer report, which is one of those reports that contains information obtained through personal interviews, think perhaps reference checks, something like that, there's actually an additional federal disclosure that would be required there. Similarly, certain states have additional requirements if you're ordering credit history, and there are others to keep in mind too. So moral of the story, this isn't a complete list, so don't take it as a complete list. It's just some examples. But for this particular candidate, again, we're hiring in California. So we're really focused on two things. First, the Federal Fair Credit Reporting Act. Keep in mind the FCRA applies in all jurisdictions across the US, so you always have to comply with the FCRA when you're hiring in the United States or when you're screening in the United States. So first, we're going to make sure that we provide a clear, conspicuous, standalone written disclosure that tells the candidate you're going to order a background check about them for employment purposes. You're then going to obtain their written authorization for that background check. You also want to keep the focus on California. Don't forget that it's not just the federal law. There are state and local laws too. So for California, California has the Investigative Consumer Reporting Agencies Act. You'll hear this sometimes called ICRA, an interesting acronym. But keep in mind there is a separate disclosure required under ICRA and also a summary of rights for California. So you'll want to provide that to your candidate also. All right, so I mentioned we already had the package designed for this candidate. Let's talk a little bit about what that looks like. So first, credit reports. You'll remember that California Labor Code does not allow employers to order credit reports about candidates or employees unless they qualify for one of a predefined list of exceptions. Those are all written right into the Labor Code, and you see the citation on your screen in case you need it. So for this particular role, again, help desk analyst, they actually don't qualify for any of these exceptions. And so you would not be ordering a credit report, right? We're not going to order one because the law doesn't allow us to. So this is a good example of why you will probably often hear us say that you want to design your screening packages based on really two things, the roles and then the jurisdictions. Having just one package that you use for everyone in your organization that kind of throws the book at it. You're ordering criminal history, you're ordering credit reports, you're ordering driving records, you're ordering verifications, everything you can think of, just throw it all in there, isn't usually the best practice, right? So there will be jurisdictional laws like California's that say you can't order certain things absent an exception. It's also likely that these things wouldn't be relevant for every role, right? Maybe your janitorial staff would have different qualifications than your HR staff, than your finance staff, your technical staff, your executive leadership. So really important to keep that in mind as you're designing your packages. A friendly reminder before we move on from this slide, if you do hire in California and you do order credit reports, keep in mind that California's Consumer Credit Reporting Agencies Act, the CCRA, not to be confused with the ICRAA, has an additional credit-specific disclosure that is required. So if you run credit checks in California, there's another disclosure that you'll need to provide, and it has to you have to select the specific purpose under the labor code for which you're ordering that report. All right. So we know we're not ordering credit history. What are we ordering? So this is the screening package that we've designed for the help desk analyst role, the hypothetical role in California. So first, criminal history screening. This is probably going to be a county and a national criminal history check, probably looking at counties where the candidate lives, where they have lived, maybe going back a defined set of time, and where they've worked, just to cover the bases. We're going to order employment verifications. So let's say that this particular organization that we're talking about here, they rely really heavily on experience, right? The big qualifier for the role is the experience. What have you done? Where have you worked in the past? So we want to make sure we verify that, right? That's going to be that important to our decision-making process. We want to know that they actually have the experience they're telling us that they have. We're going to do social media screening. So maybe this particular help desk analyst has a lot of internal and external exposure. Perhaps they would deal with all of our internal employees and also the public and our users and our customers. So there's a lot of exposure, and we've decided that perhaps this would be a good job relevant search to help us. And lastly, we'll talk a little more about this in a minute, but we're going to do a drug test. We're going to do an oral fluid drug test. So a little bit different than your traditional urine-based 5-panel drug screening. We will talk about why we're doing that in just a couple of minutes. And this is it for this particular role. Now, keep in mind, this isn't what the package would be for every role in this hypothetical organization. It's also probably not going to be the same for every organization, right? Every organization's help desk analyst package is probably going to look very different. For example, a different organization may put heavier weight on education. Maybe they say in order to qualify for this role, you must have a bachelor's degree in some sort of technology program. So that organization may order an education verification, right, to make sure they have that experience. But again, like I mentioned on the last slide, just really important to make sure you're tailoring these specific to the roles people are applying for. As an example, you'll notice we don't have driving records on this particular list, this package. This is a help desk analyst, so they're going to sit at a desk. They're working from home, so they don't drive on company time. They don't even have to drive to an office. They don't drive a car, a company car or anything like that. So whether they're a really frequent speeder is probably not super relevant to how well they can do this technical role. So we haven't ordered it, right? We're thinking about what's relevant for that job. Also really important, again, to tailor it to the jurisdictions. Each jurisdiction has such different requirements that it's really important to look at each one. And you may not be able to order the exact same thing in every single jurisdiction. Alonzo, I think you have a really nice comparison for us of how this might look different across jurisdictions. So you want to take us through that?
Yeah, absolutely, Nicole. And thank you to our audience. We're starting to get some questions in. I'm slowly pecking away, getting some answers to you, but please keep engaging with us. We always love this audience engagement. And I think that the point that Nicole has made is worth repeating. Compliance in background screening isn't one size fits all. You hear me say that often if you attend some of our other webinars. Just because something's legal in one place doesn't mean it's legal everywhere. Screening laws, they're hyperlocal, and the same job can carry very different legal obligations depending on where the candidate lives or where the work is performed. A question we often get is, how do we know what law applies where? Fortunately, the answer is it depends. It depends on how that particular law is structured. In many cases, you want to identify the work location and adhere at minimum to that particular work location's laws, but you may also need to consider the place that the individual lived as well. We'll talk about that more in a minute. But let's go back to our help desk analyst example. In Los Angeles, pay transparency, ban the box rules, THC testing limits, they all shape what we can say, what we can ask, and what we can test for. Post that same help desk analyst job in Boston, and you'll face a different mix of ban the box and pay equity laws, but fewer restrictions on credit checks. Move it to Dallas, and most of those requirements disappear. That's why it is so important to work with legal counsel who understands those local laws. And then once you've worked with your counsel, to operationalize that strategy with your screening provider. A centralized approach that can offer consistency, but it has to flex for local nuance, or then it becomes a compliance risk. Again, compliance isn't a one-size-fits-all activity. So let's talk about some of those variations, starting with ban the box. Ban the box sounds simple, right? But in practice, it's one of the most complex compliance zones in background screening. What's ban the box? Well, at its core, ban the box legislation delays when an employer can ask about a candidate's criminal history. But every jurisdiction has its own variation of that rule: what you can ask, when you can ask it, and how you must respond once you get that criminal information. Some places only restrict early inquiries. That's what you see in that gray column. Others, shown in aqua and blue, require modified pre-adverse or adverse action notices that identify the potentially disqualifying criminal history. That's what you see in that aqua column. Or individualized assessments. That's what you see in that blue column. And in jurisdictions like LA and New York City, you need city-specific documentation or substantially similar forms. And then there are some laws like Gainesville of Florida that go even further. They treat criminal history as a protected class under anti-discrimination rules. We've seen that recently happen in Minneapolis. The key takeaway is this: ban the box compliance isn't just about timing, it's about process. You have to know when you're allowed to ask, how you assess what comes back, and what procedural safeguards you owe to that particular candidate. How do you afford them their rights? And if you're hiring in multiple jurisdictions, you're going to need flexibility built into your workflows so you don't apply a one-size-fits-all model that inadvertently breaks the law in some of those more restrictive locations. Quick side note, if you are a HireRight customer, you can, of course, use our Compliance Workbench solution to help you comply with these jurisdictional requirements. So let us know if you'd like any information about Compliance Workbench when you complete today's survey. I should also mention that we've linked to our Ban the Box white paper and our Ban the Box 101 webinar in the resources section of this webinar. So check them out if you'd like to learn more about Ban the Box and fair chance compliance. If you're hiring today, chances are good that you're subject to some form of pay equity or pay transparency requirement, even if you don't know it. These two legal trends are related, but they're not the exact same thing. Pay equity laws prohibit asking about prior compensation because using salary history can perpetuate those historical pay gaps. Pay transparency laws require you to disclose compensation ranges, sometimes benefits or other pay-related details up front, often in that job posting itself. Let's start with pay history bans. These laws exist in dozens of states and localities. You can see that on the map on the left. In most cases, these bans apply not only to direct questions, but also to indirect inquiries, like asking for W-2s or using a third-party recruiter who asks on your behalf. Now let's look at that other map, pay transparency. This is where we've seen a huge legislative push over the last 2 years. don't miss this nuance. Some jurisdictions like Washington State and Colorado require disclosure even if the job is fully remote. So long as the work could be performed in that jurisdiction, you're subject to that law. That means that you employers who hire remote workers will likely have to post job pay ranges if you would consider candidates from Washington State or Colorado or any of those other jurisdictions that include remote workers. So the bottom line is we're basically trending, I would say, towards full pay disclosure transparency if you're hiring remote workers, full stop. So again, that means your remote jobs, like our help desk analyst role, might trigger multiple compliance requirements depending on who applies. So whether it's about what you can't ask or what you're legally required to share, compensation transparency is really a huge compliance issue now. And it's not going away. If you'd like to learn more, I've included a link to an article I wrote covering pay equity and transparency laws in this webinar's resource section. Take a look at it for a deeper dive into this topic. You'd be surprised how often employers default to pulling a credit report without realizing that in many jurisdictions, that's simply not allowed. So the map on the screen shows where credit checks for employment are restricted by law, and you're going to notice that it's not that short of a list. Here's the, I guess, easy thing, or the easy takeaway. Most of these laws follow what I'd consider a similar model. They prohibit credit checks unless the role involves specific responsibilities. Nicole touched on this earlier. Things like managing money, accessing financial accounts, handling proprietary business information, or holding a managerial position as defined under that state's labor code. Some states go further. I like to pick on Colorado, for example. Colorado's law requires the employers to explain how the candidate's credit information is, quote unquote, substantially related to the job when they make an adverse employment decision. That means you have to modify your adverse action notices if you're taking actions based on a credit check in Colorado. That takes me to the point. It's also worth noting that in many of these states, the burden of proof is on the employer, not just to justify the check, but to show that the role qualifies under the law. That means your documentation matters. So what is the key takeaway here? Credit checks are not general purpose screening tools. They are limited use instruments and only for the right roles. Social media has become a more frequent or common part of the screening conversation. A lot of employers are interested in this, especially for customer facing or high trust roles. But here's what many employers don't realize. More than half of US states restrict how and if you can access a candidate's personal social media. Let's start with what's prohibited in most of these states. You can't ask a candidate's login credentials. You can't require them to accept a friend request just so that you can like peek behind their privacy settings. And you can't retaliate, meaning you can't take an adverse action if the candidate refuses to hand over access. But here is where it gets tricky. These laws generally don't prohibit employers from reviewing publicly available content. So if a candidate's Instagram is open to the public, or if their TikTok shows up on a Google search, you're allowed to take a look, but you still have to be careful. Why? Because even if the content is public, you could still be exposed to bias risks like seeing religious views, political affiliation, sexual orientation, or medical information, all of which could later be used and tied towards a discriminatory hiring claim. This is why many employers who conduct social media screening choose to use a third-party provider like HireRight and our solution provided by FAMA, and somebody trained to review only job-relevant, legally usable content and redact protected class information. Really important to see how you can navigate social media screening effectively. So yes, social media screening is a valuable tool, but if you're not navigating these laws carefully, you're not just checking character, you are checking a compliance risk. Marijuana laws are where compliance and culture collide. On the one hand, you've got a growing list of states legalizing both medical and recreational cannabis. On the other, you've got employers trying to maintain safe, productive, and I'd say legally defensible workplaces. So where's the rub? Where's the tension? Well, a positive THC test doesn't always equal impairment. And in many jurisdictions, you can't take action based solely on the result of a positive test. So let's start on the right side of the screen here. So these are states that protect medical marijuana users. If a candidate is a registered patient, you might be required to accommodate legal off-duty use. So you can limit, you may have to limit what you test, and you may have to avoid discipline unless they are in a safety sensitive role or visibly impaired at work. Now, let's take a look at the left side of the screen. This is where things get a lot more complicated. These are jurisdictions that protect recreational or adult use users too. So let's take a look at California and Washington. California and Washington, these laws prohibit adverse action based on non-psychoactive cannabinoid THC metabolites. That means you can't discipline someone just because they test positive on a hair or urine test for THC. In New York and Minnesota, cannabis is treated as a lawful off-duty activity under state labor law. That means you can't fire or refuse to hire somebody just because they legally use marijuana outside of working hours. Other states have layered requirements around notice, exceptions for certain rules, and limitation on testing methods. Add to that local ordinances like Pittsburgh and Philadelphia, they ban pre-employment testing for medical users. And you've got what I'd consider a legal minefield here. So how do you manage all of this? First, you review your drug testing policy and you confirm that it's aligned with the jurisdiction where your employees work, not just where your company is based. Second, consider switching to oral fluid testing where appropriate. Again, California and Washington. Unlike urine or hair, oral fluid is better at detecting recent use or impairment and avoids flagging past lawful off-duty activity. And finally, remember this. Marijuana laws aren't just about the substance, THC. They're evolving really to consider things like privacy, fairness, and shifting norms in the modern workplace. So it's important that you keep up with this. It really is a quickly evolving area of the law. So to learn more about credit checks, social media screening, drug testing, you can check out last quarter's 101 webinar. It's called On the Fringe, or any of the other related references that we've linked to in the resources section of today's webinar. So now that we've covered some of the jurisdictional nuances, let's get back to our help desk analyst role in LA. So Nicole, let's pivot and talk about Ban the Box and the LA Fair Chance Ordinance.
Sounds good. Yeah, so we're, of course, ordering criminal history. We talked about that earlier as part of the screening package for this hypothetical help desk analyst. So one of the things we need to think about is the LA Fair Chance Ordinance. Now, important note here, our candidate is in the city of Los Angeles. This is different than unincorporated LA County, which has their own completely different fair chance ordinance. So just really important to keep that distinction in mind. We're going to focus on the city of Los Angeles in this particular slide. The city's got some really good resources actually on this. So if you do hire in the city of Los Angeles, you might consider giving those a review. You may find them helpful. They're actually right on the city's webpage. So how did the Fair Chance Ordinance impact the screening for this hypothetical candidate? Well, we actually talked about it right in the beginning. I just didn't necessarily point to it too much. We maintained some mystery, but this really started with the job posting and the application, right? We were very careful what we put on our job posting. We didn't say anything that would lead people to believe that we would just automatically refuse to hire anyone who had criminal history. In fact, we explicitly said we would consider qualified candidates with criminal history. We were careful on our job application. We made sure we didn't ask any questions that would elicit criminal history information. We didn't request any criminal history information from our background screening provider until after the conditional offer had been extended. Those all stem in part from the LA Fair Chance Ordinance. So we start to see those impacts really early in the process. Now, of course, there are also some impacts in the review and adverse action processes. So if we were to get criminal history back on this hypothetical candidate, which we'll talk through in a bit more detail in a little while, we would need to do a few things. First, we'd need to conduct a written individualized assessment. And Alonzo's actually going to take us through individualized assessments in a few minutes at a pretty high level. So I won't spend too much time here. But really the goal is to link the criminal history to the job and try to figure out, are they really and truly relevant to the job that the person is applying for? If we were to determine that this hypothetical candidate's criminal history is in fact relevant to the job and we thought we might want to move forward with adverse action, would first need to go through a pre-adverse action process. Now you'll remember there is, of course, a pre-adverse action process under the federal FCRA and also under California law. So pre-adverse action as a concept isn't unique to the city of LA, but there are some nuances that are unique. For example, with the pre-adverse action notice, we need to include a copy of our written individualized assessment. This is different than the federal law. The FCRA does not require this. And again, we'll talk about all of the requirements and everything we would include in just a little while. But another important nuance and difference to call out here is the waiting period. So in the city of Los Angeles, under the Fair Chance Ordinance, employers have to wait a minimum of 5 business days between the pre-adverse and adverse action notice. That should sound pretty familiar because that's what we typically would say would be best practice under the FCRA. So the FCRA requires a reasonable period of time between a pre-adverse and adverse action notice. The FTC has opined that 5 business days is likely reasonable, so that's typically what's considered best practice. But LA takes it a step further. They make it a mandatory 5 business day minimum. So of course you can wait 7 days, 10 days, anything more than 5 business days. But the minimum is 5 business days, and it's not just best practice, it's actually what's required by the Fair Chance Ordinance. So something important to keep in mind. And again, we'll keep reminding you throughout this presentation, we've mentioned a few times, these requirements change a lot from place to place. What you see here on the screen for the city of Los Angeles is completely different than what you would see on the other coast in New York City or in Chicago or anywhere else that has a Fair Chance Ordinance. So just important to keep in mind, make sure you're looking to the requirements of the specific laws that apply to your screening program and not just to these ones, because they will actually be really different. Okay. I also mentioned that our screening package for our hypothetical candidate included social media screening. Now, Alonzo took us through the different state restrictions on these, and there are quite a few. And of course, our hypothetical candidate is in California. So we need to keep in mind that employers in California are not allowed to require candidates to provide usernames or passwords for their social media accounts. So as part of the screening we're doing on this hypothetical candidate, we're going to make sure that we don't ask for that information. And not only we're not going to ask for it, but we're not going to try to find any workarounds to try to get to their private information. Right? We're not going to send them friend requests or connection requests, nothing like that to try and access what isn't just public information. Our focus is going to stay on public, job relevant information. And again, like Alonzo mentioned, we want to be really careful to make sure we're not looking at protected class information, right? We don't want to run into anti-discrimination or EEOC issues here. So in this hypothetical scenario, we're doing this through our screening provider. And that has a lot of benefits. Of course, it's a time savings. We don't have to have employees scrolling through people's social media profiles. Also helps with consistency. We know we're using the same search methodology with the same social media websites. There are more of them out there than I ever knew existed. So it's good to know that this is being done consistently and not just based on what different employees know to exist as social media, which for me was about 3, and I was really surprised to see the list. So what the other benefit we get by doing this through our screening provider, they're going to help filter out some of the information we don't want to see. So we don't want to know everything this candidate has ever posted on Facebook or LinkedIn or X or whatever all the rest of them are. We just want to know what's relevant to the job they're applying for, right? What do we need to know to make our decision about this particular candidate in this particular role? And so our screening provider, instead of sending us just a link to a social media profile to scroll through ourselves, has helped to filter the information. And they're going to send us back just what aligns with the criteria we've given them as being job relevant, right? They're also going to help to filter out that protected class information we don't want to see. So it's kind of just an extra layer of protection and compliance support to make sure that we're only looking at what we want to see and helping to get the rest of that, keep it away from our eyes so we're not even looking at it. There could never be an argument we considered it because we never actually saw it, right? If we were to get any results back on this particular candidate, like Alonzo mentioned, they'd go to trained reviewers. So we would have a team who's been trained specifically in reviewing social media results. What should they not be looking at? What should they be looking at? How can they avoid any implications of bias seeping into our review process? And we'll make sure that there's a structured program for them, a specific process to follow to conduct the review. And of course, we're reviewing each individual candidate's results on an individual basis, right? But it's at least a streamlined and structured process that they can follow. And at the very end of that process, we would make sure that our trained reviewers are documenting their decision making so that if we ever need to go back to it, we know how we got to the decision we made. The last really important thing to note here, if you do social media screening through a screening provider, like in this hypothetical scenario, the FCRA and all of the state level FCRA type laws, like ICRA we talked about earlier, they apply, right? This information is coming back to you in a background report. So the FCRA applies just like it would to your criminal history reports. So if you do end up moving forward with adverse action, which again, we'll talk about in a few minutes, that's important to keep in mind, right? The FCRA's pre-adverse action and adverse action process, and any similar ones under state law will still apply. And the last thing I want to talk about really quickly is drug testing. So I mentioned that for the California candidates, like this hypothetical help desk analyst, we're doing an oral fluid test instead of a urine-based test. Now, we know from what Alonzo just showed us that California has some pretty tight restrictions on THC use by employers. So employers can't penalize employees for off-duty use of marijuana. They also can't penalize employees or candidates for the presence of non-psychoactive metabolites in a drug test. So these are your markers of historical drug use. So what an oral fluid test does, and Alonzo touched on this briefly for us before, this is going to look for what are called the psychoactive metabolites. So these are your markers of more recent use and impairment. So instead of looking for that historical use, we're going to look to see what's really recent. Are they impaired right now? So that's just to help us align with these pretty unique California requirements. But again, just like all the rest of this stuff, look to the laws that apply for where you're screening, because these really do change a lot. So Alonzo, do you want to take us through how to build a good adjudication process?
Yeah, absolutely. Thanks, Nicole. And thank you again to our audience for the engagement. I just wanted to clarify one thing. As we're talking about drug testing, we're getting a lot of questions about exceptions. And yes, to our audience, remember that DOT positions are generally accepted, or on an exception basis, I should say, for all drug screening laws. This would also include any federal requirements or federal contracts or bonds. There are some nuances. I can go into those in a little more detail when we get into the Q&A in just a few minutes. But let's dig into adjudication. So this is one of the most common and most misunderstood parts of the background screening lifecycle, the adjudication process. So what is adjudication? At its core, it's about evaluating whether the information returned in that background check report disqualifies a candidate from the job. But how you do that and how consistently you do it, that's what matters. Your process has to balance legal obligations, job relevance, and fairness. That balance gets tricky when criminal history is involved. Here's where adjudication gets especially important. You, the employer, are the decision maker. Even if your screening provider applies filters or flags potential conflicts, that's not a final decision. The final call, that is yours. And your reasoning, your documentation, that may come under scrutiny. So what makes an adjudication process more defensible? Well, defined decision criteria tied to your job requirements, documentation of your individualized assessment, more on that in a minute, consistency across similar situations, especially as it relates to similarly situated job candidates, and then a built-in review process, escalation process for complex or edge cases. So I'll give you an example. Let's say our help desk analyst candidate has a 10-year-old misdemeanor for trespassing. Your adjudication policy might flag that offense, but does it truly relate to a remote IT support job? If your answer is no, and you document your reasoning, that's a strong compliance position. But if you reject the candidate without considering that context, or if your team reaches different outcomes for different candidates with similar records, that's when you increase your risk. So ultimately, a fair and defensible adjudication process is one that applies the law, aligns with business necessity, and treats people, not like data points. Let's humanize the decision. And just like the rest of the screening lifecycle, adjudication isn't set it and forget it. Audit your process, train your team, review your outcomes, because the decisions you make here shape not just your workforce, but your legal exposure and your reputation. So now that we've covered the big picture principles of adjudication, let's talk about something essential. Your adjudication standards must align with the role. Not every job carries the same risks. That's why a one-size-fits-all approach doesn't work. There are three core factors that should guide your standards. First, industry. Banks, healthcare providers, transportation companies often face legal hiring restrictions. For example, FDIC rules under Section 19, state healthcare laws, and FMCSA drug and alcohol standards all impact who you hire. Second, role type. The job duties matter. A theft conviction might disqualify somebody in payroll, but not in landscaping. A DUI might matter for a delivery driver, but not for a remote help desk analyst who isn't driving. Adjudication criteria should reflect the responsibilities of the role. Always think about role type. And third, here's one that is often misunderstood or maybe completely forgotten. That's your contracts. If you're bound by federal contracts or customer requirements, those terms may dictate specific background check standards. Your adjudication policy needs to reflect those obligations without overreaching, narrowly tailor them. So what's the bottom line? Adjudication it's more than compliance, it's really risk management, but it only works when it's calibrated to the job, the risks, and your business environment. So when reviewing your adjudication matrix, and remember to do that periodically. When you review that adjudication matrix, ask, does this disqualification make sense for the role? Ask, does this disqualification make sense for the role? If not, it's time to adjust. So let's take a look at the EEOC's guidance on criminal history. Back in 2012, the EEOC published enforcement guidance on the use of arrest and conviction records in employment. And while it's not new, it's still one of the most influential documents shaping how employers should evaluate criminal history. The guidance centers around what we call the green factors, named after a landmark case. First, the nature and gravity of the offense. Not every criminal charge has the same weight. A felony theft conviction isn't the same as a misdemeanor disorderly conduct. Second, the time that has passed since the offense or the completion of the sentence. People change, right? A decade-old conviction may not reflect who the person is today. And third, the nature of the job being sought. This is where job relatedness comes into play. A conviction for financial fraud might be relevant for an accounting role, but probably not for a warehouse position. These factors serve as the framework for conducting what's known as an individualized assessment, a best practice that's now required under many state and local fair chance laws like those in California, New York City, and Philadelphia. During this assessment, you give the candidate an opportunity to provide context, evidence of rehabilitation, errors in the report, or mitigating circumstances, and you document that process. If there are errors in the report, you obviously encourage the candidate to file a dispute. We'll cover that in a minute. The EEOC, they don't say that you can't consider criminal records, but they do expect you to do so in a way that's fair, consistent, and related to that job. And increasingly, so do state and local governments. We've included a link to the EEOC's 2012 guidance in today's webinar. Check it out. It's a very, very helpful resource. So what makes an adjudication policy strong and defensible? First, your criteria needs to be job-related, consistently applied, and grounded in business necessity. If challenged by the EEOC, a regulator, or a plaintiff's attorney, you want to show that your decisions weren't arbitrary. They're consistent. Second, define clear decision levels. At HireRight, we often use pass, review, or fail. A pass means the candidate meets your criteria. A fail or does not meet means that they don't. Review, pending potential conflict, for example, signals something needs further evaluation. Next, establish an escalation process. Gray areas happen, and your team needs to know when and how to bring in HR, legal, or your compliance team. Fourth, train your adjudicators. They need to understand the policy rationale, know how to spot red flags, and recognize when to escalate up so that you can get a decision. And finally, maintain a thorough audit trail that includes timestamp notes, decision logs, records of candidate communications. All of these are extremely important. If you're ever audited or sued, documentation can be your strongest defense. So the bottom line here, a well-built adjudication policy protects the business, it supports fair decisions, and it reflects your values as an employer. I'm going to just quickly walk through the adjudication lifecycle. This is what happens when the background check report is complete. First, your team, your HR team, hiring manager, adjudicator, they review the results. If something gives you pause and you're thinking not to move forward, that's your cue to start the pre-adverse action process. Nicole is going to talk about that more in a second. Once that review is done, you either proceed with the final adverse action or hire the candidate, and each step carries specific legal requirements and timelines. So Nicole, let's say something shows up on our help desk analyst report. Walk us through what happens next.
Absolutely. So we've gone through the review process, the individualized assessment process. We've done a written individualized assessment because we are in the city of Los Angeles. That's one of our requirements. So now you're at the pre-adverse action stage if that is the decision that you had made. So what does pre-adverse action look like? We need to keep in mind a few things. First, of course, the Federal Fair Credit Reporting Act, as I mentioned, applies across the country. So we need to make sure we're keeping that in mind. So we're sending a pre-adverse action notice that includes a copy of the report and the FCRA summary of rights that's put forth by the CFPB. Then we also need to keep in mind state and local requirements. So we're in Los Angeles, California. So our pre-adverse action notice is going to call out the criminal history that we think may disqualify the candidate. It's going to give them a copy of the written individualized assessment, and then the state and local summary of rights as is necessary. Then we're going to wait. We're going to give them a minimum of 5 business days. And again, under the LA Fair Chance Act, this is a requirement. It is not just best practice. So we have to wait at least 5 business days. Now, remember that time frame changes from jurisdiction to jurisdiction. There are actually some that are as long as 10 business days. So keep that in mind as you're designing your pre-adverse action processes. Now, during this 5 business days, the candidate has the opportunity to do a few things. First, they have the opportunity to contact us and give us any additional information that they think we may need, anything they haven't told us yet that might help us make our final decision. They also have the opportunity to contact the background screening company, the CRA, and file a dispute. So if they do choose to do this, let's say they contact the background check company and say, you got something wrong with my criminal history. It's not quite right. So they'll call out what's not right, and the consumer reporting agency, again, the background screening company, will reinvestigate that information. So they have 30 days to do this. Sometimes that can be extended to 45 days, but generally background check companies have 30 days to get this done. So what does this look like on the employer side? Well, as the hypothetical employer for our help desk candidate, we're just going to press pause, right? We're not going to make our final decision. We're not going to try and fill the role with somebody else. We're just going to wait. The reason for this is we don't want to make a decision to deny somebody employment based on information that's not right or not true. So we're going to wait and let the background screening company do their reinvestigation and determine if the information is in fact accurate. Then we'll make our decision once that's done. So after this is done, let's say the background check company gets back to us. They say we made an update to the report. The new report's available. They will contact the consumer, the candidate, and they'll also tell them that the dispute's done and let them know some information about what the outcome was. If the dispute isn't resolved, once the reinvestigation is done, the candidate actually has the right to file what we call a rebuttal statement with the background screening company. So this is just a short statement that explains their opinion on the dispute, the circumstances of the dispute. If they choose to do this, the background screening company will include that information in future reports that have the disputed information. We're going to say our hypothetical candidate didn't do this. They didn't want to put this statement on there. So just something important to keep in mind. If you ever get a report that has a statement like that, this is likely why it's there. And then what happens next? Well, let's say our candidate contacted us and they gave us just a little more information that we want to take into account, we need to take into account in making our final decision. We, of course, also have the updated report post-dispute. So we're going to do another assessment, another written individualized assessment that takes into account the new information in the report and the new information from the candidate. And we're going to make sure that it's really the right decision. Let's say that once we've done that individualized assessment, the final decision is we're going to move forward with adverse action. So what is that going to look like? Well, again, a few things to think about. Of course, first, the Federal Fair Credit Reporting Act. So we need to send them an adverse action notice. We need to notify them of the adverse action. We need to give them the name and contact information for the background screening company. Let them know the background screening company didn't make the decision, can't tell them why the decision was made. give them some information on the right to file a dispute, right to get a copy of their report. But then again, we also need to think about state and local requirements. So we're also going to give them some information on their right to file a complaint with the California Civil Rights Department. We're also going to give them a copy of that final report that we did our reassessment on and our written reassessments so that they can see the reassessment that we did based on the post-dispute report and also on that new information they gave us. And then we're also going to include just all of those summary of rights documents, just as a reminder to the candidate of the rights they have and what they have going forward. And that kind of closes out the adverse action process. The last key piece, and I think we touched on this a little earlier, we're going to document everything. So we're going to keep copies of those letters and the dates that we sent them. We're going to keep the individualized assessments and things like that. So we're going to keep a bit of a paper trail that documents the decision we made and how we got there. And that just helps us be able to demonstrate our compliance with all of these different requirements that apply throughout the adverse action process. And that's the end. That closes the process for this particular candidate's background screening. Alonzo, do you want to wrap us up really quick? And then we have a lot of really good questions, I think, to get to.
Yeah, let's bring it home. And I am excited about these questions. If you take just one thing from today, let it be this: background screening isn't a moment in time. It is a process. It begins long before you click order, and it doesn't end when you get the report. Your job posting, your disclosures, your internal criteria, your adjudication decision, all of that matters. And it's all governed by a mix of federal, state, and local rules that you need to account for in every single screening decision. We've walked through how laws vary by jurisdiction, how a candidate in Los Angeles, for example, might require a completely different process than somebody in Dallas or Boston. We've talked about how adjudication isn't just a preference or a policy, it's a compliance obligation grounded in EEOC guidance, fair chance laws, and court interpretations. And maybe most importantly, this work isn't set it and forget it. Document what you do, train your team, review your process regularly, and then do it again. This needs to be a consistent process. This is a life cycle. It is not a set it and forget it moment. Because when screening is done right with transparency, fairness, and consistency, you don't just reduce risk, you build trust. You make better hires, and you strengthen your company's integrity from inside out. And that is a wrap on today's prepared content. Here is a quick plug as you continue to get your questions in for our Q&A session. We have several outlets of information for you to consume. So if something piqued your interest, check out our resource library, blog, and Forbes articles to learn more. And snap that QR code and connect with me on LinkedIn, where I post a short video covering a new compliance topic every week. I'm posting every single Friday. So let us know if you'd like any information about any of HireRight's services or solutions, like Compliance Workbench, our credit checks, social media screening solutions, drug tests, or our adjudication tools. We can get you information about any of those things or modifications to your account settings when you complete today's survey. So just let us know. And with that, let's open it up for questions. Nicole, what do we have?
A lot of good questions. First, we have some questions on specific state requirements for credit reports. So I know our last webinar, our 101 webinar, was on the fringe. So just as a reminder of what that included, we cover in that webinar credit history, age discrimination, pay equity, and pay transparency. I know we have a few social media questions. We did cover social media. So if we're not able to cover your question here today, I do encourage you to give that one a look. We covered a whole lot of topics in a really short period of time, but there's a lot of information there, so that might be helpful. Okay, first question up. This is a really good question. We haven't seen this one in a little while. Are the requirements the same for volunteers as they are for direct hired employees? Do you want to take that one?
Sure. So at the federal level, the EEOC has, I'm sorry, the FTC has opined broadly. So the Federal Trade Commission has said that the scope of employment is really broadly defined. So it can include things like non-traditional workers, like your contractors, and it can also include volunteers. So in terms of your FCRA compliance, meaning providing disclosures and authorizations and adhering to the pre-adverse and adverse action process. All of that is in scope under the Fair Credit Reporting Act. So you would absolutely want to comply. As it relates to state-specific laws or city-specific laws like ban-the-box laws, this is a little more of an it depends answer. And I know that lawyers love to give it depends answers, but this one is certainly justified. Some jurisdictions say that any work, whether it is or is not for pay, would be applicable to a ban-the-box jurisdiction. So that would include your volunteers. Others specifically exclude volunteers. So unfortunately, it's something that you're going to have to look at from a jurisdiction to jurisdiction basis. We do have a ban-the-box white paper made available in the resource library if you'd like to take a look at that. Otherwise, what I would say is that you're always welcome to over-comply than under-comply, right? So if there is any question as to whether or not a law applies to a volunteer, you might just consider including your volunteers in that population for compliance purposes. Great question, though.
Absolutely. Okay, we have a set of questions that we'll answer all together. These are really around different types of dispositions, so dispositions other than convictions. What is your guidance or opinion on pending cases and deferred adjudications? Do we have information on any ban-the-box laws that might specifically call these out or have different rules? How would employers handle these?
So that's a very nuanced question. And again, I would say that some jurisdictions specifically exclude an employer's consideration of a pending case. They would say that you may have to do something more in that particular case unless there is some sort of unreasonable burden applied to your organization or some sort of regulatory issue that may come into play that would cause you to deny those individuals. Other jurisdictions say that you can treat a pending case as something on which you can take action, upon which you can take action, meaning that you could actually choose to perhaps disqualify that individual from a role. And then, in other cases, you may consider accommodating them in a role where there is lesser risk introduced to your organization. So unfortunately, this is, again, one of those it depends situations. You'd want to consider the laws of that particular jurisdiction. Our ban-the-box white paper does get into that in some detail, but you'd want to look. We do include links, though, to all of the ban-the-box jurisdictions, the actual statutory ordinance language. You'd certainly be welcome to dive into that. And, it's something maybe that we could consider as part of a larger webinar at a later time. Great topic, though.
Absolutely. We have a couple of different questions around what qualifies as social media, and I am probably the worst person to answer this question because I have one social media account and know of two other platforms that exist. But Alonzo, we've got a couple asking if LinkedIn qualifies and what else actually qualifies as social media.
Yeah, unfortunately, so I have I've been fortunate or misfortunate, depending on who you ask, to have had a deep dive into social media laws recently. I've been doing a lot of research here. And what I've learned is that there is very little consistency amongst how social media laws are crafted, or drafted, I should say. So some specifically identify like the types of social media content. Others are more agnostic and broader in their reach. None specifically call out the platforms that would fall under scope for those particular laws. So again, this is another it depends question. I think that the LinkedIn angle, though, is particularly interesting because the question of whether LinkedIn is a professional or a personal outlet, I think is something that is very gray. I think some workers, some people who contribute to LinkedIn are increasingly treating LinkedIn as a personal platform versus a professional platform. So I think that what I would consider when reviewing LinkedIn content that is private, so for example, if you were an employer, maybe you're a recruiter and you friend your candidate and your candidate has a private profile and your intentions on friending the candidate with a private profile is to look maybe into some of the personal aspects of their lives, I'd caution against that, right? I think that your intent is really what plays into the decision as to whether or not you should be accessing that social media content. One more quick one, Nicole.
All right, let's see if we have a really quick one. We have a lot of really good questions, but not a lot of. Here's one we can probably get to pretty quickly. This is around allowing candidate input for individualized assessment. The question is, do we need to call candidates, or are we allowed to do this during the waiting period? When do we need to allow candidate input, and what's a good way to go about doing this?
So you should engage the candidate in a conversation and get their input immediately upon seeing any sort of criminal history that gives you pause. And the way you handle that is up to you. You can take a phone call or you can do this in written format. But at the end of the day, you want to make sure it's documented. And with that, I think we're going to go ahead and close out. So thanks again for spending part of your day with us. Before you go, we'd really appreciate it if you took a moment to complete the short survey. It takes less than a minute, and your feedback helps make these sessions even better. Keep an eye on your inbox. We're sending out a link to the webinar recording along with your SHRM and HRCA credit and confirmations next week. On behalf of Nicole, myself, and everybody here at HireRight, thank you for joining us. Be sure to save the date for our 2025 Compliance Year in Review webinar. It's happening January 14th. Registration details are coming soon. Until then, take care and stay compliant. Thanks again, everyone.